Okay,
50 miles south of Boston.
that's right.
Mhm.
Great. Yes, a northeaster is definitely coming.
Yep. Hi, Trina.
Yes, thank you both for joining me. The live sessions are a lot better when you're here.
Mhm.
Wonderful. It is exactly 6 o'clock Central Standard Time, so we're going to get started. This is going to be a great live session for both of you because we are going to have a quiz review, and I wouldn't even imagine taking the quiz without the review. Especially because when I started teaching this course, I revised all of the quizzes to make them more student friendly. So I've taken the quiz and I know exactly what's on it. So we're going to have a very good quiz review near the end of this live session. So let's talk about Module 4. We're getting into the Statute of Frauds, which is an English doctrine. So most of our law in America was brought over from England. It's called the common law because it's judge-made law and it's common to everyone. Certain aspects of the common law have been codified. That means they have been adopted by the legislature and written into statutes. The statute of frauds has been adopted, I think, in most states. So what is the statute of frauds? Well, the statute of frauds says certain contracts have to be evidenced by a signed writing or they can be enforced. So we know at common law, all you need is an offer, acceptance, and consideration to form a contract. But in order for 6 types of contracts to actually be enforced in a breach of contract action, they actually have to be evidenced by a signed writing. So you can remember these 6 types of contracts, Stormy, using this acronym called MyLegs. M is contracts for marriage. In England, there was a dowry associated with the contract. So if the bride backed out of it, the groom wouldn't get the money. So that was a marriage contract was actually enforceable in England if it was in writing. In America, contracts for marriage are void against public policy. We know how hard it is to hold together a marriage in America. So, yeah, marriage contracts are actually void against public policy in America. But in England, a marriage contract was enforceable if it was in writing. Contracts that cannot be performed within a year. A year from now, there's no way we're going to remember what we said today. So, contracts that cannot be performed within a year need to be evidenced by a signed writing, signed by the party who's being sued for breach of contract. So the person that you're trying to enforce the contract against has to show that they actually agreed to it through their signature. Contracts for the sale of land. Every parcel of land is considered to be very rare, and we know these days it's also very expensive. Real estate prices have been going up like crazy in the last few years. So contracts for the sale of land, because every parcel of land is rare, must be in a signed writing, or that contract for the sale of land cannot be enforced. Executor contracts, contracts for the sale of goods greater than $500. That's codified in the UCC 2-201. So I think that number has actually gone up now to $750. So contracts for the sale of goods greater than $750 must be in writing. Otherwise, they are not enforceable in a court of law. The last type is a suretyship or a guarantor contract. A guarantor is like a co-signer. A co-signer is someone who stands in the shoes of the original contracting party. So if you were to co-sign for a relative's car purchase, then that co-signer, guarantor, the person who is guaranteeing and co-signing for that loan would need to sign that. And that guarantor co-signer agreement would be in writing. Okay, any questions about the kind of contracts that must be in writing to satisfy the statute of frauds? Great. Perfect. So I would know that for the quiz. Let's talk about your Module 4 assignment. You're being asked to write a memo this week. In this scenario, Jill and Will are independent contractors. They have completed technology projects for people and businesses. However, they've never sold parts before because they did not want to have to collect sales tax or deal with the paperwork. In the past, their carefully selected customers have always been great. Collection of bills has not been difficult, so they decided not to use a written bid or a written contract. So, Stormy, do you think the statute of frauds would be implicated in a case like this? If they decided, if Will and Jill decide they're going to start selling parts and they have contracts to sell maybe $750 worth of parts.
Yes. In that case, then they would be bound by the UCC 2-201, and it would have to be in writing.
Exactly. Great. So, let's assume that Will and Jill come to your law firm. They talk to your boss, Mary. Mary wants you to do a survey of recent cases and articles on the statute of frauds to make sure that you understand the law, the current law concerning the statute of frauds, so that you can give legal advice to Jill and Will. So this is a research memo. So here's what you want to do to complete your research memo. First, find a recent case on Lexis Advance on the statute of frauds. Find a recent article in Rasmussen's online library, and then search the web. Go to google.com and search for any type of blog discussing the statute of frauds. Then go back to Lexis Advance and research the statute of frauds in your state. In Massachusetts, in Minnesota, you want to get your state's version of the statute of frauds. And it may not even be the UCC provision. There are other provisions. In some parts of the civil code pertaining to contracts, there's a statute of frauds. In some states, there's a statute of frauds concerning the sale for land, and it's actually separate. And we have a question about how to do the memo from Trina. Let me open up the chat. When we are researching this, do you want us to type that information in the analysis section? That's good. This assignment is saying for the appellate case, complete and include an IRAC analysis. So no, I would actually organize the memo according to these questions. 1, a recent case in Lexis, and you should IRAC that case. 2, a recent article in the Rasmussen Online Library, summarize that in a paragraph. 3, a legal blog regarding the statute of frauds, summarize that in 1 or 2 paragraphs. 4, cite to the statute of frauds in your state. So no, that would not be in the analysis. The IRAC is only for part 1. Trina, when you're describing that recent case, you would IRAC that case. Use the Blue Book citations for every source. So basically, your memo will be organized in 4 sections. You'll cite and describe the case, doing an IRAC, identifying the issue in your recent case, the rule the court followed, the analysis of the facts in that case, and the conclusion the court reached in the case that you find. The second section, you'll be discussing your article. The third section, you'll be discussing the blog you find on the internet. In the fourth section, you can simply cite to the statute of frauds in your state. So organize it according to these 4 questions. Okay, we have an ongoing discussion forum in Module 4, and it is asking you about legalese. That's one of our topics for this week. Often, the language that lawyers use is very complex. Why? Because it was brought over from England. And some of the terms we also use, some of the legal terms are based in Latin. A couple of legal terms that we use are based in are French terms. So yeah, sometimes legalese is very hard. So in the module form discussion forum, you want to just provide an example of legalese and then explain what makes that example so difficult. Let's go into the online classroom, and we're going to look at some examples of legalese. I'm going to share a web browser. Going to go into, there we go. Go into this discussion forum and take a look at what's going on in our module discussion on legalese. So by now, everyone should have made their first post. Sure. Sure, Stormy, what was your question?
Okay, so when you were talking about how they should be set up, so what you're saying is that the case that we come up with, we need to break that down into the IRAC method, and then that's it, and
Yes.
then move on. Okay, because I had done the same thing and kind of set the whole thing up as the IRAC and included all the information, but it's not supposed to be that way, right?
Well, you know what? Go ahead and submit what you did, and if it's not right, I'll let you know.
Okay. So like not each one has to be broken down in the IRAC method.
Only the first one.
Only the first case. Okay, perfect. Thank you.
It's a good question. I remember when I was in law school, I hated Iraq. It just so many things in the law are so counterintuitive, and it's a whole different way of approaching problems and of thinking. So it really took me a while, hi Kim, to really learn how to do the IRAC and to have a vision of Iraq, and to really find a case and really focus and narrow down the issue, and to really focus and get the rule and focus on the analysis. And that's, what I'm seeing in people's writing this term is some people are better at really narrowing down the issues in a case than others. Okay, any more questions about that assignment? It's optional. You could use the same piece of paper. I mean, you could use the same page or separate. As long as you have met all 4 of the criteria: the case, the article, the blog, and the statute of frauds in your state. One piece of paper, 2 pages, that part, it doesn't really matter. If you tabbed over to the second page, that's fine. As long as when I download your assignment, I can see that all 4 parts have been supplied. So let me just show you very quickly how to figure out what the issue in the rule is when you are IRACing a case, because I've noticed some people are not as good at this as others. Fast case. I'm not supposed to have to sign into this. Okay. Books and tools. So I'm gonna take a look at a case and show you how I would IRAC it. There we go. All right. So if I was to search a statute of frauds case in see what I come up with. 1980. So I'm going to organize this from newest to oldest so that the newest cases will be on top. So I just did a search for a statute of frauds case, and I found one involving leases in multiple jurisdictions. Okay, here's one from Delaware. All right, this case is recent enough. Facts. Defendant has claimed throughout these proceedings that there was an agreement for the sale of property, but can present no evidence under the statute of frauds. So this is a very short case and it's easy to IRAC. So the issue in the case is whether or not there is a written agreement for the sale of property to satisfy the statute of frauds. The rule is that no contract for the sale of property can be enforced under the statute of frauds unless it's in writing. So the analysis would be defendant has claimed throughout the proceedings that there was an agreement, but he can present no evidence that's sustainable under the statute of frauds. Nothing in the record provides defendant with a legal justification to continue maintaining his property, personal property. Defendant does not satisfy the requirements for defense to plaintiff's motion to eject. The reason why defendant's being ejected is because he doesn't have any evidence that he ever purchased the property. So the conclusion would be defendant does not have a valid contract for the sale of property that can be enforced. You want me to demonstrate it on Lexis Advance? I don't have a password for that. But the search would be the same. You would just log in with your password and you would search in the upper left hand corner. There's like several dots. When you sign into Lexis Advance, you would just pick your state. Just like this, there is a box. You would simply search through the box. You would enter your search terms in that same box. It's a natural language search. You would enter statute of frauds and you would get a list of results. You would simply sort those again by the newest date, and you would simply pick a case. Here's another case right here. So once you have your case up, all right, in this case, ERG, an investment consulting firm, brought an action against a limited liability company to enforce a non-disclosure agreement. Okay, so this is an action for breach of contract. Defendants have moved to dismiss. Let's see what the issue is in the case. Because sometimes the issue in the case, and there we go, legal analysis. So the issue in this case, you can really skip through the facts when you're trying to find out what the issue is. Go down to the legal analysis section of your case, Kim. Any case that you find on Lexis Advance, you want to determine whether or not it's a good case for you to cite. This case is really talking about a matter of subject matter jurisdiction, whether the court has the authority over a party. That's not the issue that I want to deal with. And how I found that out is I went under this section called legal analysis, and I see that the court is talking about personal jurisdiction. I am looking for a case that talks about the statute of frauds, so therefore I would not pick that case. I would look for a different case in my list. And here's a case. Yeah, skip the facts, okay? Facts don't matter, right? We're looking at the issue, the rule, the analysis, and the conclusion. So the first thing we need to do, what is the legal issue in the court? This is a summary opinion, and there's no rule of law being discussed. So yes, some of these cases that you may find are not going to be a good case for you to use in your research memo because it does not provide enough laws or rules or holdings. So here's one right here. Okay, so now I found a case that's talking about breach of contracts. So at least I know that this case might be relevant to the research memo. So the first issue in this case is a breach of contract. The second question says, the first issue they're talking about here is a contractual obligation existed. So this would be a good case to cite if you're talking about how to know whether a valid contract is formed. Unless the statute of fraud applies, an oral agreement is perfectly enforceable. So this case is about an oral agreement. Again, Part B, the statute of frauds. Okay, so there is a statute of frauds issue. Party G argues that the statute of frauds prohibits Party B from bringing a claim. Delaware statute of frauds prohibits enforcement of an oral agreement that is not to be performed within the space of a year unless the contract has been reduced to writing and signed by the party against whom enforcement is sought. Okay, so the issue in this case, here's how you would do your IRAC. The issue is whether the statute of frauds prohibits Birmingham from being able to bring a claim under the alleged oral contract. The rule is that Delaware statute of frauds prohibits enforcement of an oral agreement that can't be performed within a year. Okay, here's the analysis. Okay, here's the analysis in the next couple of paragraphs. It looks reasonable that the parties would think that Gil Renan could have settled into the house and repaid the $13,000 back within a year. Therefore, the statute of frauds does not apply. And there's the conclusion. So sometimes the court will give you the conclusion. And that's the judge, I find that the parties' actions constituted a binding agreement for the payment of $13,000 to be made in a reasonable time. The statute of frauds does not bar recovery because the contract can be performed within a year. And there's your conclusion. So does that make sense, Kim? Okay. So yeah, so when you're doing research, sure, you're welcome. The first thing you have to do is you go through this, and all I did was I just did a search for the statute of frauds. I didn't even limit it to jurisdiction. And the second thing I did is looked for the most recent cases. Then I looked to see if the statute of frauds is really the issue the court was focused on, or was the court focused on something else? Here's a case from Ohio. No, this is also a Delaware case. It's about a lease. Shopping centers were closed during 2020 due to COVID. It's probably going to be an action for the breach of the lease to rent a space in the mall. And the statute of frauds is an issue. Here we go. This action involves leases. The statute of frauds varies in each of the 16 jurisdictions. The statute of frauds would not apply to the leases formed in Ohio, Texas, Massachusetts, and Oklahoma based on the laws in those states. Even in those jurisdictions where the statute of fraud applies, the court is unable to make the appropriate determination of the law. Many issues of fact appear within the statute of frauds, as are presented by the oral modification of the contract. So this would be a good case to cite to if the issue is whether or not somebody was not able to perform a lease because of the disruption of the property due to a COVID-19 closure. That's the issue in the case, is whether there's been a breach of the lease due to the closure caused by COVID-19. One of the issues is whether the statute of frauds is going to apply. The court doesn't have enough information to determine whether it does or not. The rule of law apparently is that the statute of frauds would not apply depending on what state's law was at issue. And I would not cite to this case because it does not make any conclusions that would be helpful as the statute of frauds. So when you're doing your research, you have to do some sifting to find out whether the case that you've found that the research case is actually helpful in your memo. And we can see that some of these cases are not helpful. So you would just skip that case and you would go to a case that is directly on point, that really discusses the statute of frauds. Really, our scenario is the sale of goods. So let me see if I can find a case where the statute of frauds is actually being applied to a contract for the sale of goods. Here we go. Here's one right here. Looks like it's on point. A case from 2009. This is a debt action by plaintiff supply company to collect on an invoice for specially ordered equipment. That's a contract for the sale of goods. Okay, let's see what our issue is by skipping all this, getting down to the court's decision. Both parties agree there was no written contract for the sale of the control center. Therefore, the question is whether there's an oral contract. And then, is it unenforceable under Delaware statute of frauds, which requires a sale of goods over $500 to be in writing? So these would be your issues. Issue one in this particular case is whether or not there's actually a sale. And two, whether or not there's actually a contract for the sale of goods. Two, if there is an oral contract, is it actually enforceable under the statute of frauds? Because if it's a contract for the sale of goods of $500 or more, Delaware statute of frauds requires it to be in writing. So there's your issue. And now we need to know what the rule of law is. Here's the rule of law. To form a valid contract, there must be a bargain, which is a manifestation of mutual assent to the exchange and the consideration and meeting of the minds. In addition, a contract must contain all material terms in order to be enforceable. So there's your rules. Here's the analysis. The facts do not establish that the parties reached a complete meeting of the minds. As such, no valid contract came into being. So if there's no contract, we don't need to worry about if the contract satisfied the statute of frauds because there is no valid contract. So this would be a pretty easy case to IRAC. The issue is whether or not there's an enforceable oral contract. The court says, states the rule. To form a valid contract, you need a bargain, you need a meeting of the mind, and it's mutual assent and consideration. And then the court analyzes that and says, you know what? There's clear from the testimony the parties did not have a meeting of the mind regarding the essential terms of price and design specification. The conclusion, no valid contract came into being. So this would be an easy case to IRAC. It doesn't help us much because there's no analysis of the statute of frauds because the court doesn't get to that question because it says there's no contract anyway. Okay, any questions about how to do the research for this module 4 assignment? Okay, great. Computer-assisted legal research is truly wonderful. So now, all right, the next thing that's happening in Module 4, boy, I need to get back to that. Okay, the next thing that's happening in Module 4 is our discussion forum on legalese. So by now, everyone should have posted an example of legalese, and the assignment asks you to look at another student's example of legalese and try to correct it. So let's see. There's a lot of great examples. Here's one presented by Megan. So the one that Megan provided was legal language that says, in witness whereof the parties hereunto have set their hands as these presents as a deed on the day and month and year herein before mentioned. What do you think that is, Stormy?
Sorry. Can you just repeat that? I'm sorry.
No problem. Megan presented an example in the Module 4 discussion form of some legalese that she found. Here's the language that she found. In witness whereof the parties hereunto have set their hands as to these presents as a deed on the day, month, and year herein before mentioned.
Okay, what was the question? Just how I interpret it?
Yeah, what in the world does that mean?
What is that? Yeah, to me, it just looks like a bunch of words on a page, and I have no idea what I just read.
Okay. Yeah, it's really, that would be considered Old English. No one in the United States typically talks like that. So I interpreted it below for Megan. What it is actually is it is a witness. It's an attestation that a witness would need to sign, verifying that they have observed the transfer of a deed to property. So a common law, to have an enforceable transfer of land, you had to have two witnesses, and the witnesses would sign below to say that they witnessed the transfer of the deed of property. So that's actually what it is. So my interpretation, the following two names listed below are witnesses to the transfer of this deed on the date specified above. Usually the witnesses would simply sign that piece of paper and put the date. So that's actually what the court is talking about. Witnesses signing that they observed the transfer of a deed. Why couldn't they just say that, you know? Here's an example from Vanessa of the legalese that she found. It says, the agreement and the document shall be governed by the substantive laws of the state of Minnesota, and the bank and borrower consent to the personal jurisdiction of the state and federal courts located in the state of Minnesota. What that's called is a forum selection clause. So oftentimes these days people are contracting with parties who might be in different states. So if I enter into a contract with Stormy for the sale of a computer, I'm in Nevada, Stormy's in Massachusetts. Because of our complex legal system and our history in America, Nevada has its own set of laws. Massachusetts has a whole different set of laws. Stormy, if you sued me for breach of contract, whose laws would apply?
I would think it would be the laws of the person who signed off on the contract.
It's actually more complicated than that. When I was in law school, there was an entire class called Conflict of Laws. It was taught by this guy named Professor Bratton. He was actually a really, really good guy. Anyway, there is a whole set of laws used to resolve conflicts. One way to avoid any confusion is for us to put in our contract, Stormy, that Massachusetts law will apply to this contract for the sale of a computer. And that is what the example that Vanessa has cited does. It says the agreement shall be governed by the laws of the state of Minnesota, and the parties agree to be sued in the state of Minnesota. So that's one way to avoid a conflict of law issue, is to put in a forum selection clause in your contract that says, in the event of a breach of contract action between Stormy and Catherine, Massachusetts law applies, and both parties will be subject to the authority of the Massachusetts court, which means if Stormy sues me for breach of contract, I have to get on a plane with my mask and fly to Massachusetts and appear in court. So that's basically what this legalese says. If there was not a provision in the contract, then you would have to go to a set of legal principles known as conflict of laws, and you would apply those to figure out which state's law to apply, and it'd be a lot more complicated. So everyone just make sure that you participate in the Module 4 discussion forum by Saturday or Sunday, present your example of legalese, and then simplify one of your classmates' examples. Any questions? Okay. Here are some more exaggerated examples of legalese. Here's one. In the event that the contingency of the failure to promptly fulfill the order for 1,000 widgets occurs, the buyer's option obtain cover, substitute goods from another supplier, or otherwise act so as to obtain the aforementioned goods that were not delivered. What does that mean, Kimberly? Any thoughts about that, Trina? What does this language mean? In the event of the contingency of the failure of the seller to fulfill the order for 1,000 widgets, the buyer may, at the buyer's option, obtain cover, substitute goods from another supplier, or otherwise act as to obtain the aforementioned goods that were not delivered. What do you think, Stormy?
I think basically what it's saying is that if the order is failed to be fulfilled, then the buyer can go to another supplier and get the substitute goods.
Yes, cover. So that would be the UCC remedy of cover. So a widget is just a generic term that means somebody bought an object. So it's just, widget is a term for any object that somebody bought. So it could be 1,000 nails. So if there's a contract for the sale of goods greater than, $750, greater than 500, whatever the amount is, and that's a contract for the sale of goods under the UCC, and the seller doesn't ship the goods, the buyer can cover or obtain substitute goods.
In that
That's all
case,
that's saying.
wouldn't first the seller have the 10 days opportunity to cure? Does that still apply?
Well, if there's a defective delivery,
Okay.
that would apply. But in this, it sounds like the failure to promptly fulfill the order. So
Got it.
I'm not going to read into that scenario. I'm just going to say, notice it says obtain the goods that were not delivered. So I'm going to assume that there was no delivery.
Got
So
it.
if there's no delivery, the buyer can treat that as a breach of contract and obtain cover goods. If there was a delivery for 500 widgets, then the buyer should give the seller notice of the defect and give the seller the opportunity to cure under the UCC. Yeah, you're right. So if it was a defective shipment, then the buyer would need to give the seller the opportunity to cure. But if there's no delivery whatsoever, the buyer can cover.
Got it. That makes sense.
Yeah. So again, there's rules of it, the law. There's rules. The UCC applies to any contract for the sale of goods. Only the statute of frauds has the dollar amount. So the UCC applies to any contract for the sale of goods. But the people, the parties to the contract, can add their own requirements as long as they don't change the UCC. So if they want to, add a provision like this, telling the buyer that they have the option to cure, or telling the buyer they have the option to cover, the buyer has that anyway under the UCC. But if they want to specify that in the contract and make it even more clear, hey, that's great. Let's look at the next example. The buyer has failed to promptly notify the seller of the intention of the buyer to refuse either to pay the price or explain failure to pay, and has failed to indicate non-acceptance of the aforementioned goods, and the reason thereof said failure, as to so indicate, the seller shall refuse to stop deliveries and shall continue to invoice them for further notice. So if the seller and the buyer have what's called a regular contract for requirements or output, and the buyer does not notify the seller of the buyer's intent to refuse to pay for the next shipment, or explain that they're not able to pay, or if they fail to indicate non-acceptance, the seller can't stop delivery and she'll continue to invoice them until they get notice. So what we want to avoid in legalese is double negatives. Like this last sentence, refuse to stop deliveries. Double negative means you can just cross that out. Saying if the seller can't stop, that means the seller has to continue to make deliveries until they get notice from the buyer to stop. So that's a double negative. That's something we want to avoid in legalese, is a lot of double negatives. Seller shall refuse to stop. That means the seller continues to deliver goods until they get a notice to stop. So legalese is bad. So again, in the discussion forum, be sure to simplify a classmate's example to make it more readable. Problems are often there's too much repetition, too much complexity, double negatives. Two negatives cancel each other out. One way to avoid legalese is to use short sentences, and that's also true for your own memo writing. Use short sentences. There is a strong trend in the law to use brevity, shorten, be short, sweet, and to the point. Judges don't have a lot of time. Your supervising attorney does not have a lot of time to dig through useless facts and details about a case. Be very brief, use short sentences, avoid redundancy, stop refusing to supply, avoid double negatives. Here's an example. Dale rejects, denies, and refuses to accept that the promise is contractual. You could simplify that just by saying Dale denies that the promise is contractual. Here's the next example. at that point in time, whereupon and in the event that the goods are delivered, June will pay the price. All you have to do is say, when the goods are delivered, June will pay the price. Does that make sense, Stormy?
Yes, it does.
Yeah, there's a strong, strong trend in favor of simplifying and removing redundancy, double negatives, and removing legalese from your writing. So, and some of you are already doing that, which is great. But yeah, in your memos, you do not want to discuss every single fact of the case that you're citing in a memo as authority for some legal proposition. If you're explaining a case that you researched and you found, you want to be brief. You do not want to get into a lot of legalese. Let's have a review of the rules of grammar. A lot of my students, even in PhD classes, struggle with grammar. So let's do a quick review of the rules of grammar, because this will be on the quiz. A sentence must have a subject and a verb. The subject is the person doing the action. The verb describes the action that's being done. The subject and the verb must agree in terms of whether they are plural or whether they are singular. Bob and Tim is friends. Has anybody ever heard that? Somebody say something like that? Bob and Tim is friends. You ever heard that, Trina? Catherine and Stormy is friends. Trina says, no, I have heard it. I've read it, and it was recent. Yeah, they is friends. So is a singular linking verb. It cannot go with a plural subject. So it would be Bob and Tim are friends. Are is a plural linking verb. Bob and Tim are friends. So just make sure that your subject and verb are in agreement as to whether they are plural or whether they are singular, because trust me, judges are old enough to know, because they were taught the rules of grammar when it was really taught well in school. They know whether it's supposed to be is or are, and if you don't have the right thing, they're not going to respect your appellate brief when it comes before the court. So you want to make sure that your appellate brief, your memo, your legal writing has the correct noun and verb agreement. Here's the next one. Neither Bob nor Tim is going to the party. Neither Bob nor Tim are going to the party. Which one is right, Kim? Yes, because when you use neither, it's the first one. Because when you use neither, that's singular. Neither Bob. So it's like Bob is not going to the party. Tim is not going to the party. Neither Bob nor Tim. So that's a singular example. That's a tricky one. The third one, Shamika walked to school. I know you've heard that. I heard that when I was growing up in Virginia. Shamika walked to school. Or is it Shamika walks to school? Which one, Kim? Yeah, Shamika is singular. When you have a singular subject, you need to add an S to the verb to make it grammatically correct. Shamika walks to school. If it was Shamika and Samantha, then it would be they. They walk to school. But Shamika walked to school is when your subject and verb are not in agreement, and you are not going to get an A if you submit that to your English professor. So if you want more examples of this, check out the Purdue Writing Lab online. I've searched that before, I've Googled it. They have great grammar exercises. I'm going to send out this PowerPoint presentation, and that will have a working link to the Purdue Writing Lab's learning exercises for grammar. So it's worthwhile to make sure you know those because, like I said, when I teach PhD students, they still get this wrong. So, any questions before we have our quiz review?
I have a question, and I'm sorry. I'm going to take you back again, if you don't
Sure.
mind, to the written assignment.
Yep.
I wrote it down because I didn't want to forget to ask. It is the additionally for the appellate case on a statute. Is that a second case that we're to break down, or is that just talking about the first one?
Yes.
Okay.
And it would have been great if the assignment had put that with one.
Yeah, that's why I wasn't sure if we were supposed to do two, like an appellate and a first run case. So that was it. Thank you.
Here's the key. When you're using Lexis Advance or Fast Case, the majority of those decisions are appellate decisions because a trial court decision does not have the authority. It does not have much precedential value. A case doesn't have very much precedential value until it's been heard by a higher court. And the highest authority in America is, of course, the United States Supreme Court. The United States Supreme Court only hears appellate cases. So when you're researching on Lexis or Fast Case, 90% of the time you're looking at appellate decisions because the trial court decisions are not published because they don't have very much precedential authority or value. So yes, that refers to that first case. And it should have been written like that. I will make a note to fix that if I can in the learning materials because that makes it more logical. So yeah, that first case is the one that gets the IRAC. Good observation, Stormy. Any more questions before we start our quiz review? Okay, so yeah, I revised this quiz. I think it was last year to make it more user-friendly. I took the quiz, I got an A, so that means you can get an A too. And here is what you need to know. What are the three elements of a valid contract? Trina, can you help me out with that? What are the three elements of a valid contract? Kimberly, do you remember the three elements of a valid contract?
Oh, the offer, acceptance, and consideration.
Brilliant. That's it. Do contracts have to be in writing, Kimberly? No, they don't. The only time a contract needs to be in writing is to satisfy the statute of frauds. Oral contracts are perfectly enforceable. What is the law that applies to service contracts? Stormy, what do you call the law that was brought over from England and our judge made law that we apply
Common law?
to? Brilliant. It's the common law. The UCC is a special law that has been codified and written into statutes by the legislature. What rules apply to contract for the sale of goods over $500? Stormy, what do you think?
Would be the UCC 2-201.
You don't have to worry about the subsection.
Oh, okay.
UCC just stands for the word Uniform Commercial Code. It
Got it.
has hundreds of provisions in it. 2-201 is one provision. So it's just the UCC as a whole. The Uniform Commercial Code applies to contracts for the sale of goods. There's a special rule for remedies. There's a special rule for cover. There's a special rule for cure. There's a special rule for the statute of frauds. So there's a bunch of different 2 dashes this and 2 dashes that. But the overall concept is UCC. That is the name of the code itself. Good. Kimberly, what is consideration? So you pointed out that consideration is one of the elements of a valid contract: offer, acceptance, and consideration. What is consideration? How would you define it? Could you give me an example? The beginning of the bargaining process is the offer. One person expresses a manifestation of a willingness to be contractually bound according to certain indefinite terms. That's accepted. Under those same terms, there's a meeting of the mind. What is the consideration, though? If I offer to sell you a computer for $500, what is the consideration in that example? What do you think, Stormy?
I think the consideration would be that the offer and an acceptance is mirrored, and the person would have to accept the offer. It's like
Okay.
the meeting of the minds.
Okay.
That's what's being offered is understood as what's going to be agreed to.
That's called the mirror image rule. So that would cover the offer and the acceptance. Consideration is anything of legal value that's bargained for. It is the subject matter of the contract. So if we have a contract for the sale of a boat, and I agree to sell you my boat for $500, the offer is I would like to sell you my boat for $1,000. Stormy would then say, I accept your offer. The consideration is the thing that we're bargaining for. I'm bargaining for the money, you're bargaining for the boat. So the consideration is the subject matter of the contract. It is the thing of legal value that we're bargaining for. So it is that third element of a contract. The first element's offer. The second element is acceptance. And acceptance should ideally at common law fulfill the mirror image rule, which means that I'm accepting the same exact offer, the terms of the offer. You could lay the offer, you could lay the acceptance, and they would mirror each other. That's the mirror image rule. But the third element of the contract is the thing that we're bargaining for, and that's the consideration. It has to have legal value. Kimberly, why should you put a contract in writing? Why would you want to? Yeah, it's evidence, right? A year from now, we may not remember what we said. So having the terms of the contract in writing makes it easier when you go into court and you have a breach of contract lawsuit. And it makes it easier to prove the terms of the agreement. It makes it easier to prove that there was indeed an enforceable contract. Otherwise, an oral contract is enforceable. You would just need to use testimony. People would go into court and testify, and the judge would determine if they're a credible witness, and then they would believe what they're saying. If you ever watched Judge Judy, she's very good at reading the credibility of witnesses, and she will tear a witness apart if she thinks they're lying. Have you ever watched Judge Judy? Yeah, a lot of times she is enforcing oral agreements. People come into court, it's an oral agreement to rent an apartment, it's an oral agreement to sell a car, it's an oral agreement to buy a cell phone from someone, it's an oral agreement to make a loan. And sometimes she'll try to look at their cell phone text messages to determine. She'll have both people testify, and she'll try to figure out, well, was there an enforceable agreement? And if so, what are the terms? Well, if Judge Judy believes the testimony of the witness and thinks that they're credible, that evidence is just as good as a signed writing. So that's how you would prove up an oral contract in court, is through testimony. But in an ideal world, we'd have those contracts in writing, and it would be easier to prove them up just using the documentary evidence. And that would certainly make lawyers happy. And last but not least, Stormy, can you please tell us one more time, what is the statute of frauds?
The statute of frauds is the rule that if anything of goods is sold over $500, then it must be in writing to be an enforceable contract.
Right. And more specifically, there are 6 types of contracts that must be in writing.
My
The sale
legs.
of goods. Yes. The sale of goods is one of those 6 types. Contracts for marriage, contracts for the sale of land, contracts that cannot be performed within a year, an executor agreement, suretyship, guarantor, all of those need to be in writing to satisfy the statute of frauds. And the whole point is, if you didn't have a contract for the sale of land, imagine how easy it would be to commit fraud. You would just go pointing at people's land and say, "Hey, I bought that. That's my land. You get off my land." Well, if you need to have a contract to evidence the sale of land, it makes it a lot easier to avoid that type of fraud. Same thing with marriage contracts. You know, people could walk around all day saying, "Hey, we had a contract to get married, and I was supposed to get the dowry. I was supposed to get my money, and I married you, and I didn't get the money." You know, so that's why those contracts must be in writing to avoid fraud. Co-signers, you know, people would always say, "Oh, well, my mom co-signed for me." Well, where is that writing? Where's the co-signer agreement? So that's why that has that co-signer agreement. If you're going to put a third party on the hook for your loan, then that has to be evidenced by a signed writing. Because a lot of parents do not want to co-sign for their kids' cars. Have you ever seen that? A lot of parents do not want to co-sign for their kid's car. So somebody saying that they co-signed for you, that has to be in writing to be proven. Otherwise, Judge Judy is going to throw that case out. I like Judge Judy. Most court TV shows are great. You can learn a lot between Forensic Files, Criminal Reenactment, and Judge Judy. Okay, this is a tough quiz, so let's keep going. What should a paralegal do if she finds an error in a contract, Kimberly? What would you do if you found an error in a contract? Yeah, show it to the supervising attorney, and then they can rewrite it, they can revise it. Kimberly, what is IRAC an acronym for? What does IRAC stand for? I know Stormy knows this one. What does IRAC stand for? Okay, Kim's got it. There's just a little delay in that chat. I stands for issue, R stands for rule, A stands for analysis, C stands for conclusion. IRAC is a way of breaking down your case, putting it into a format where you can easily get to the information that you need, the issue, the rule, the analysis, and the conclusion. Why do we use the IRAC tables? We've had that in several assignments where you've been asked to prepare an IRAC table. What's the point of that, Kimberly? It's not just torture. Good. Trina says organization. Good, Trina. I mean, it's a way to identify the issues, right? If you're doing an IRAC table for a case that you're working on as a paralegal in a law firm, you're preparing this information for your supervising attorney. You want to know what the issue is that you're facing. You want to know what the applicable rule is. You want to know, you know, the blanks in the IRAC table are areas where you would need more facts, more information from the client, and you might need to do more research. So it does help you to organize your casework and to find out what additional information you need. What is the restatement second of contracts, Trina? What is the restatement second of contract? Yeah, it's a treatise. There's a restatement of torts. There's a restatement of property. When I was in law school, I liked Corbin on contract. That's the treatise that my teacher used. There's also Williston on contract. I don't read the restatement of contracts very much. I like Williston on contracts and Corbin. To me, they explain contracts really well. But there's a restatement for conflict of laws, and it's like a dictionary or like an encyclopedia. It's a treatise. It is a secondary legal source. A primary legal source would be the cases the judicial opinions that are rendered by the court and the statutes that are coming out of the legislature. Those are primary sources of the law, statutes and cases. Treatises are secondary sources of the law. They're not binding, but they're very persuasive. It's a great place to start doing your research, is using the treatises. Why do we use Lexis Advance and Fast Case, Stormy? What are they?
They are primary cases and statutes, and it's just a reliable and credible premier legal research.
Exactly. And mostly that last part, Lexis Advance and case law, Lexis Advance and Fast Case are premier boutique legal research services. So they're premier legal research services. They're more reliable than using Google. They are premier because, we're paying for that service. The school is paying for that service. The cases are organized in a certain way that you can search them. So Lexis Advance is a premier legal research service provider. Okay, let's start talking about the Uniform Commercial Code. So switching gears to the Uniform Commercial Code, which is a set of rules to facilitate the free exchange of goods between states in a vibrant marketplace. You have a contract under the UCC for the sale of goods. Kimberly, what are the seller's duties under the UCC? What does the seller have to do in a contract for the sale of goods? What are the seller's obligations? Well, a seller has to deliver the goods, right? Trina got it, yeah. Deliver the goods. The buyer has to accept the goods. They're their basic obligation. If the seller is selling 1,000 nails for construction project, the buyer is buying 1,000 nails. The seller's obligation is to deliver the nails. The buyer's obligation is to accept that shipment and then to pay for it. Now, the buyer has remedies under the UCC. The buyer may reject the shipment if it's non-conforming. But the duty, the seller has to deliver, the buyer has to accept and pay for. Okay, that's the end of our quiz review. Any questions about what else might be on the quiz? I really think that this list covers it. This is what you need to know, are the answers to the questions on these 2 PowerPoint slides. This week, we also have a live session question. In order to get credit for the live session, you must submit the correct answer to the live session question, which is, what are 3 remedies the buyer has under the UCC? You can get that off of Google. Please submit the correct answer by Sunday, January 30th. So all of your assignments for Module 4 are due on Sunday. The discussion forum post, the quiz, the memo, and a live session question. But there's no need to wait to Sunday. You can start doing those assignments tonight, right? Some of you have already done your assignments and have already submitted them. Thank you very much. And all of your assignments for Module 3 will be graded by me by Friday at midnight. That's the school's policy, is you get your assignments graded by Friday at midnight. So I'll be busy grading on Friday. Thank you so much for attending the Module 4 live session, and have a great week. Bye, Stormy. Bye, Kimberly. Bye, Trina. Thank you so much for joining me.